All right, just testing. Somebody please in the chat say whether they can hear me or not. All right. All right, and let me commence at 6:01. All right, and now let me just adjust this and let me commence. My name is Mr. Max Chaudhary from Chaudhary Law Office. I'm an immigration lawyer in Toronto, Ontario, Canada, and I've been an immigration lawyer for 30 years. I have a law firm called Chaudhary Law Office, and there's two other lawyers there. They assist me with the various types of legal Canadian immigration applications, such as visas and federal court and proceedings at the Immigration Refugee Board and the Citizenship Department. So, with that in mind, I want to remind people that this is being recorded, and the purpose of the recording would be to put portions of this on social media. That's very important because you want to pose questions that are phrased in an anonymous way so that you keep your anonymity during the course of this webinar, given the fact that excerpts of this go on to the social media apps, Instagram, etc. So with that in mind, also as a reminder, please feel free to pose the written questions in the chat. That might be the appropriate way. We vary it from time to time. And that may take some time for you to compose something in writing. If there's a follow-up, depending on how many people, then we could try to actually speak person to person. But again, keep in mind that if we do that, your voice would be on social media. And we're always very vigilant about confidentiality of matters. So if you're more concerned about confidentiality, then the more appropriate thing may be simply to pose written questions in the chat. And that means there may be follow-ups based on what I say, because oftentimes the response I give to a question may inevitably lead to more questions being posed. So it's always a little bit of a muscle you have to use when you're commencing a webinar from the host's point of view, but also for you, the audience members who have a specific question. There's a bit of sort of composing the issue and then writing it down. So we're here, or I'm here until 7 p.m., and I'll proceed with looking at the initial question, right? Now, what I see here is, I may paraphrase this just for the purpose of brevity, and also just to sort of absorb the nature of the question as well. So there's an individual who came to Canada in September 2023, studied 2 semesters at a college, not successful at some courses, leading to suspension, and then subsequent removal from the school program. And then the person returned to their country of ordinary residence, partly due to political issues and family issues, and then re-entered Canada. And it looks like they re-entered Canada on the basis of the study permit, which was still valid when they re-entered despite not being in full-time attendance at a learning institution. The personal circumstances include that the person cannot afford tuition to re-enroll. And then at this point, it seems returning to the home country is not an option due to, I presume, the physical illness of the father, which may lead to financial issues for the person, hence being unable to afford studies. So with that in mind, the question, with that context, the question is, can I leave and return within my visa valid until 2025? So strictly speaking, when you return on a study permit, you are supposed to get examined, which is just a legalistic way of saying getting questioned. Immigration, or in this case, the CBSA at the port of entry, such as the airport, they're not always diligent about this. So if you have gone in, if you have entered Canada on this study permit, or if you're about to enter Canada, well, it sounds like you have until 2025. It's a possible it's a possible risk in terms of what options the CBSA officer has at the port of entry. So what may happen is if they do question you, then they would perhaps come to the conclusion that you have not complied with the terms and conditions of a study permit. Then they may query your circumstances and ask you, well, what is your situation in Canada? Like, do you rent an apartment? Do you have like lots of personal items, a pet, this sort of thing? And then if you do have that kind of circumstance, such as a substantive chunk of your life is based in Canada, then they have discretion to allow you to enter Canada. But the way that discretion may be exercised is that they may take away your study permit and give you a visitor record of a limited duration. In more extreme cases, they may cancel it and tell you to return to the home country, which, depending on how fast they do this, in some cases, they could they would compel you to go exactly on the same flight, which I've heard happen from time to time. So this is all for the purpose of enforcing compliance with the terms and conditions of a study permit, which is meaning you have to be actively engaged in studies. And if you're not studying for more than 6 months, then based on the policies connected to a study permit, then you should not have the study permit from the enforcement point of view. Excuse me. And as a consequence, those two changes to your visa status could happen at the port of entry. In an even more extreme situation, they could convoke you for what's called an admissibility hearing at the Immigration Division of the Immigration and Refugee Board. And that means in some cases they could seize your passport and impose on you terms and conditions such as reporting for that hearing and reporting once a month at the Canada Border Service Agency's offices near the airport, presumably, depending on which city you're going to, until the hearing is convoked. So that's a more extreme situation. I don't know if that would happen because that's a very resource-intensive kind of thing. From the point of view of sort of bureaucratic efficiency, the first two scenarios might be more common. Namely, if they're nice, they'll let you in with a visitor record for maybe 30 days or 60 days to dispose of things. If they're not, then they would say, leave, just leave Canada. So it's an enforcement. There's an intersection of study status and enforcement obligations on the part of the CBSA that is related to that question. So there may be a follow-up to that, but in the meantime, I see a couple of questions. So I'm just cognizant of the time because we're here till 7. So this question is hopefully simple, as is written. I'm currently on a closed LMIA and have no idea about immigration and PR, permanent residency. So where should I start my learning journey and how can I prepare myself at the best of my ability? So once my LMIA expires or labor market impact assessment expires, I can either get an LMIA or get permanent residency. So to kind of tackle the potential pathways for permanent residency or additional time on a work permit, there's certain key distinctions, such as whether this closed LMIA is at a certain tier level, NOC, and National Occupational Classification tier level. In the vast majority of cases, the pathway for permanent residency has as its foundation an NOC or NOC tier level 1, 2, or 3. It's not always the case because in provincial programs, sometimes there's a pathway for permanent residency for jobs associated with less educational requirements, namely at tier level 4. But if we're thinking of the federal express entry system, then your first step is to make sure that you have a knock skill level job at 1, 2, or 3. And then another aspect of this is kind of mirroring the criteria under express entry. And what is weighed heavily there is age and education level and number of years of experience, work experience inside of Canada and outside of Canada. So that would be, in some senses, that's the way to deal with this. There's a concern that there's an incredibly high point threshold for express entry right now. And the other concern is that the express entry point system for allocating extra points for permanent residency under that express entry selection grid for working with an LMIA may be denied shortly in the spring. Normally, or at least the case is right now, that if the employer does support your permanent residency, then they can file an LMIA, and that can provide further points, either 50 if the knock level is tier 1, 2, or 3, or if it's executive knock, the higher knock, then it could be 200 points. That may disappear shortly. They've said that very categorically in the spring. So you may not want to rely on that as the basis for your permanent residency. If that's the case, if you have an express entry profile that does not have a competitive amount of points, and these days it seems the point totals are over 500 in the past few draws, then in theory you could consider provincial options, which is kind of overlapping and or separate from the federal express entry regime. And keep in mind those provincial options, unless the province is employing what's called targeted draws, such as we have in Ontario. Targeted draws meaning that the province has access to who's in the express entry profile pool, and based on, for example, your work experience outside of Canada, perhaps in a job that is where the skills are in short supply, such as in healthcare, in certain STEM jobs, then you may get selected under the auspices of the Ontario, for example, the Ontario International Foreign Worker Stream for this. So that could be sort of the basis for that would be a hybrid of you being in Canada and or having work experience that is related to a labor market shortage in the province of Ontario, such as in STEM or healthcare, things of that nature. So that's a little bit of direction about what to consider about potential pathways for permanent residency. I think there was a related question about extending the work permit, or at least implicitly the possibility of extending the work permit. So for that, you have to keep in mind that an LMIA, there is a presumption based on what the employer placed in the LMIA. In other words, what the employer argued was that the individual, namely yourself, would transfer skills to the Canadian labor market at that employer. And in other words, the ability to work on a long-term basis is finite. I believe, depending on the type of job, you can only have maybe a 5-year or 7-year work permit with extensions, and then you have to leave. Just because by their nature, work permits are temporary. So there has to be a break. You can't simply work for like 8 to 15 years on a work permit, because by its nature, it's a temporary document. So you have to, that may necessitate perhaps another LMIA, depending on the nature of the job. So with that in mind, if there's a follow-up, let me know. I'll try to proceed with what I see here with the next questions in the sequence here. So then I see something here related to parents' sponsorship, namely a parents' sponsorship application was submitted in May 2024. In December, a request for additional information was received and the required details were provided. Oops, just going to readjust this for a sec here. So, and then something a little bit unusual happened. After the required details were provided, in this year, the file was returned due to incompleteness. And the question specifically is in this case where the applicants are outside of Canada while the sponsor is inside of Canada. Is the judicial review deadline 15 days or 60 days? So traditionally, most federal court judges will say that this question depends on where the applicants are residing. In this case, it appears the applicants, namely the parents who are the subject of the application for sponsorship, I believe are outside of Canada, and as a consequence, it should be 60 days. And yes, in this kind of situation, it looks like a very odd situation, which may merit judicial review. You could retain us if need be, within the appropriate time frame. It's without looking at, for example, what you had submitted in response to the request, and of course, what the request was, then it's difficult to sort of gauge the chance of success in that case, or to consider the other options, which sometimes are reconsideration, which means typically in a situation where the mistake might be obvious, you can ask the immigration department to reconsider the refusal using primarily documents that were already filed or already submitted before the refusal decision. In other words, a reconsideration, when done properly, is meant to basically say that I already submitted the required documents and you either misinterpreted them or you failed to consider them. And here are the documents, and here was the concern you expressed, which was addressed in the documents which I submitted before the refusal. That is a kind of reconsideration course of action. Our office suggests that you do both judicial review and reconsideration because you don't want to lose the reconsideration opportunity. Or rather, you don't want to lose the judicial review opportunity, because if you file reconsideration and then they take too long to decide, then you might be out of time to seek federal court judicial review, essentially. So that sort of double approach is preferable from the point of view of preserving your rights for judicial review for this. So that's sort of the overall sort of scope of how to tackle this kind of situation. And then I proceed further here, which says this question is related to the H&C application, humanitarian and compassionate, where the person's PGWP or post-graduation work permit expired. And at the same time, the employer applied for an LMIA but received a negative result for the LMIA. And they applied for an additional LMIA, or labor market impact assessment, which is still going on. But this necessitated the need to stop working because there was no subsisting work permit to allow the person to remain in Canada working. And then the question is, would this be eligible for being a foundation for a humanitarian compassionate application? In terms of the possible assistance, it's mentioned that the company is ready to offer a job for whenever the person does have the legal ability to work. There's also a bit of background, namely that the person has no real ties to the home country, currently living with a Canadian boyfriend, but is not common law in the sense that they're not, I presume, they're not in a marriage-like relationship for 12 months, which means the Canadian boyfriend cannot sponsor this person as a sponsored spouse or a common law partner. So we're very cautious about humanitarian compassionate because the old criteria was that it had to be unusual, undeserved, and disproportionate hardship. There's some modification now because there was a case from 2015, Kanthasamy, which said that one other way to look at this is what would move a reasonable person to want to grant this kind of issuance of a visa based on sympathetic circumstances. I mean, I'm paraphrasing that. That's sort of a reiteration of a case from 1970. I forget the name of that case, but because the criteria for humanitarian and compassionate is so broad, I would hesitate to file something in this situation as a humanitarian compassionate application, unless, for example, there is something that really does stand out, like, for example, you're a minority in your home country and you don't have the support of relatives. And maybe at the same time, there is the potential for very good establishment or already demonstrated establishment, and or you provide a very key set of duties at the Canadian employer, which can maintain the employment for other people at the same place of employment, for example. So it's those are sort of some potential hallmarks for a successful H&C application. But unless there's something pretty serious in the home country, it may not be enough simply stating that, for example, I came here as a student, I studied for 4 years, and I worked for 3 years, and that's that those facts. Although you, in that scenario, that hypothetical scenario, you were here for 7 years, the way the law is rigidly structured, in combination with the what's called inventory management of the PR system under express entry, means there's no guarantees, unfortunately, despite the fact that it was quite often a kind of sure thing from 2015 until 2022. So because of that, you may want to not consider a humanitarian case unless there's some more serious issues for you in the home country or some somewhat extraordinary contribution. I mean, I'm discouraging a little bit. In a formal consultation, we tease this out and we try to sort of break down in more detail the individual circumstances of the person. And then as a result, then we can say, here's the possibility when we look at the individual's situation in more detail. But as a matter of safety, we don't want to encourage people to file humanitarian compassionate cases because, I mean, there's a time factor and there's an expectation of success sometimes. So with those caveats in mind, it's better to be cautious and, consult a lawyer, maybe one of us as well, right? If there is some sort of hallmarks of what I've described, which you think you might possess. So with that in mind, I see an additional question here. So a temporary foreign worker has a closed work permit with an employer registered in the province of Nova Scotia, but is working at the employer's client location in Ontario. So for the provincial nominee program eligibility, should the application be based on the Nova Scotia employer as listed on the work permit or the Ontario work location? So when it comes to the provincial programs, there's when I identify here the closed work permit, and the PNP programs for many provinces are job offer based. It's sort of implicit in this scenario that this is also job offer based because it's a closed work permit. So that means when it's a closed work permit, typically under the Atlantic immigration programs, the employer who's listed on the closed work permit has been vetted either by the province of Nova Scotia or one of the maritime provinces, or they've been vetted by the federal authorities in the event this was an LMIA. So for this, if it's the former, if it's the Atlantic Immigration Program, then the typical rationale for that is that there is a need of an employer in the province. It might be conceivable that this is an Atlantic immigration-based employer who may, on a temporary basis, want to dispatch the person outside of the province, where the venue of employment is typically carried out. So in this case, I really can't say with specificity, maybe with more details, about whether or not there is some eligibility. But my presumption is that the provinces, under this Atlantic immigration program, they should have some flexibility depending on the employer and the nature of the employer's business, which may necessitate that a province, or rather an employer based in an Atlantic province like Nova Scotia, may have a legitimate need from time to time to dispatch an employee to another jurisdiction outside of the province, but still nevertheless be receiving instruction and remuneration from the province. So that's sort of the optimistic scenario that I'm kind of portraying, which hopefully is the case, assuming this is under the AIP, which is what you may be considering. So I don't know if that's a specific enough answer, but based on this, on the what you posed, I think that's as specific as I can get. And then there is a follow-up, I believe the question about the person who might have not complied with the study permit terms and conditions for this. And it's what do you think I should do? Because this person has family issues and returning to Canada. It says returning to Canada to reduce the complicated situation at the airport. So I think the question is, when a person has a visa or a document like a study permit, and the compliance may not be carried out, or may not have been carried out in the past, and that may be detected if the person is thinking of coming back to Canada on that visa, which may not have had complete compliance by the person. What can be done? So if we think defensively, in some situations, if there is some kind of strong need to return to Canada, then you can try to demonstrate that with an additional application filed as a sort of backup in the event that you're subject to an extraordinary amount of scrutiny exposing the lack of compliance with the study permit. What I'm speaking about is a temporary resident permit, which is meant to correct violations that a person may have had under the Immigration and Refugee Protection Act. Now, this is also very discretionary. These could be issued at the airport, but they want to see that you have a life in Canada, and not only a life, but a strong need to be in Canada on a temporary basis. So just as an illustrative example, what that could mean is that you have an acceptance at a university or a college, and you're partway completed the course of study, and you need maybe just a couple of courses in order to graduate. Otherwise, you'll lose the entire benefit of the 2 or 3 year diploma program you were studying in. So it's extremely important that you come back to Canada. Plus, you've already demonstrated you've paid the tuition, and you're only going to be here just for a couple of semesters. And then you make that argument in a TRP accompanied by a government fee of, I believe, $200, unless it's changed. So that's a kind of defensive posture you could have ready if you do return to Canada, possessing a document, a visa, where the lack of compliance might be detected and may lead to the taking away of the status. So in a nutshell, TRP. It's very complicated, so please consult a lawyer. We are lawyers here, or whichever lawyer you're comfortable with. With that in mind, I see here some additional questions here, which is, are visa applications reviewed on an individual basis for each person, Or are there options for whole families? So, for example, if a household has no Canadian relatives, what paths are available if a family wishes to move to Canada? So, this kind of issue, at least in my mind, is uh, connotes a kind of situation where there's, let's say, a father who is a business person, and then they have children, and then one child is 22, and one child is 18, and then the entire family wants to come. The problem is the father with the business can, in theory, file for an entrepreneur application under one of the provincial nominee programs, but he'd only be able to bring his spouse and the younger child, not the one who is over the age of 22. And that means that child over the age of 22 cannot be included on the permanent resident application because they are no longer a dependent child, as is defined in the Immigration and Refugee Protection regulations. You have to be under the age of 22. So that means you have to compose a different strategy for the overage child, such as a study permit or things of that nature. One other thing that's called to mind is that when a family, let's say the family does have the appropriate age composition for the children, let's say there's a husband and wife and two kids under the age of 22, ages 19 and 17. Depending on the category, oftentimes for skilled worker categories or entrepreneur categories, admissibility of one of them could eviscerate or destroy the entire application. So if anybody in the family has a serious health condition that would cost over, I believe, the $18,000 or $21,000 per year in terms of Canadian healthcare costs, if simply one person in the family has that medical condition, then the entire family would be inadmissible. Similarly, if one member of the family has a serious criminal record, it affects the entire family's admissibility. So then arguments would have to be made for something like a temporary resident permit. Or in the case of medical inadmissibility, there would have to be arguments showing that the required medical treatment can be financially taken care of by the family, or the family can, if it's a very discrete, specific kind of condition like surgery, the family can have the family member do the surgery before they come to Canada. So I don't know if that's exactly what you were thinking about, but if not, you can repose the question with more specificity. With that in mind, let's see what is here further here. So this person says they have a knock at tier level 2, a national occupational classification job with skill level at tier 2. And the question is, what is the least amount of Canadian experience I have to have in order to apply for express entry or PNP? And where can I find support related to these? So in many, I might want to say most applications, you have to have 1 year experience. Well, certainly for the federal express entry subcategory of CEC or Canada Experience Class. However, with some provincial nominee programs, if you have 6 months of experience and a job offer, that may be suitable. And in some cases, that's typically the smaller provinces where they have this, and typically they're expecting some strong tie to that smaller province because that's the way of ensuring that you will remain in that province rather than going to the 3 or 4 largest cities in Canada. So that 6 months sort of abridging of the normal vast majority 1 year requirement is typically provincially based, tied to a job offer. And without that, then it's probably going to be 1 year in terms of the required amount of work experience that you need to have. And let's see if that's a follow-up. Let me see here. So, okay, this is a very different question. So, are there restrictions to becoming a digital nomad, namely, i.e., residing in Canada while working remotely for a US company? So, we look up, I have looked this up maybe 6 months ago, looking for some specifics about the digital nomad program. I saw the announcement about this maybe from a year before, But I saw nothing too specific about it. So in my mind, this is simply, I mean, depending on which country you're from, this is simply coming to Canada with a visitor status and working remotely, getting paid from a company or some other kind of entity which is outside of Canada, and hence will also not performing any services for that company if they have some need to do something in Canada, like if they have clientele in Canada, because then you'd need a work permit. So from that sort of set of parameters, namely simply working remotely, and the company is outside of Canada, and the services provided by that company are given to people who are not in Canada, then that should be fine. I mean, because you don't have to make any tax return for Canada because you're not working in Canada for this. So I just want to see if there's a follow-up or a related question to this, right? So, okay, so in terms of the other related question is, can you gain citizenship from being a digital nomad? So in this case, because effectively it's basically a visitor status where you're simply just uh, enjoying the Canadian scenery while you're working outside of the country where your employer is based and where your clientele or services provided are outside of Canada, then there's no real pathway for permanent residency in that situation. So you'd have to look up, depending on your age and whether you have any business experience, either express entry if your age is arguably under 35, or if you're over 35, do you have a business that you can uh, create in Canada based on having a successful business outside of Canada? Those are, broadly speaking, the pathways for permanent residency in 2025 in Canada. I mean, there's obviously subcategories of that. So with that in mind, there's no other questions in the meantime, but we still have time. So you could have a follow-up question, as the case may be, or I can give the sort of general guidance that I always like to give everybody when it comes to things like either immigration applications, or if you're needing some kind of court case, then the sort of general guidance about immigration tribunals or court cases. So with immigration applications, the huge issue that people who self-file sometimes come across is that they miss some form of communication with the immigration department, and that communication may say, for example, please submit something within 30 days, otherwise we'll refuse the case. So the solution is always just to make sure that any sort of email with the domain at cic.gc.ca or at canada.ca is listed as a safe sender, so that it goes to your inbox rather than your spam folder. Because sometimes it goes to your spam folder because there may be a hyperlink inside the email or things of that nature. So that's always fundamental, and because we always see these people who may have done a really good application, then it gets refused on a technicality, and then we have to go to federal court for something very administrative, which is kind of frustrating for the person. And the other common situation, I always have to repeat this, so I may as well here, which is that if you have a refused application, you obviously have to declare that. Another issue is if you have ever been detained or arrested, the question posed in one of the forms asks you that in very clear terms. So just because you were charged and nothing happened means you still have to declare any detention or arrest, even if it's an administrative detention and not criminal detention. Otherwise, if you don't declare these things, then you may be banned for 5 years. So I always pose these reminders to people anytime I can, because oftentimes, as the immigration system is kind of encouraging people to file things on their own, which is fine, but those are the two things that often intersect and lead to a refusal. And sometimes it's hard to undo that kind of damage. So With that in mind, I'll see the further questions here. So let's see. So I'm in the process. I'm in the express entry pool, hoping for a CRS score to drop to under 500 for CEC. Are we able to accept an invitation to apply outside of Canada if we no longer have the initial status as worker or student? So generally speaking, yes, as long as the work experience, and this would be the case. You have to file the express entry within 3 years of the depending on the category of the work experience you're relying upon. So you clearly would in this case, and you can be outside of Canada. And I always advise clients, if your work permit ran out and you get the invitation to apply, just leave. Unless your life is seriously embedded here, like you have children who are in school and there's a school year and your work permit is, let's say your work permit expires in February and you have children who are in school until June, then you can try to make some kind of arguments, but you need professional representation to do something like extend a work permit on extraordinary circumstances such as those, where there's a profound disruption arising from the need to leave Canada owing to the expiration of a work permit. So the short answer is yes. The other question we see here is, what are the timelines for judicial review, including the application for leave and the judicial review hearing? So in these cases, if you're familiar with the the federal court amount of cases, traditionally they're about 10,000 a year, and we see that by what's called the IMM number in the court cases. And I think in 2024 there was like 23,000. So this is a sign that getting to a possible hearing could take maybe about a year at least after filing the initial application for leave, and maybe even 18 months. There is a profound amount of delay because I would say, I'm sort of editorializing, but part of the reason is that for relatively simple cases where there's a simple mistake of the officer, there is not a robust reconsideration regime in place where you can simply contact the officer and say, well, I saw the refusal, but it didn't take into account this work experience letter. Can you just look at this work experience letter? There's nothing really like that except the informal resolution or the informal reconsideration, which is really hit or miss. So that forces people, as a matter of caution, to proceed to the federal court system. And so the federal court system, they've tried to innovate by having certain pilot projects. One relates to a simplified way to deal with refused study permit applications, because there are so many refusals of study permit applications, where it's a streamlined process and you don't have to file as many documents. The issue for the vast amount of refusals as well relates to the deployment of artificial intelligence, which is the Chinook. That's the sort of internal word, the Chinook system. It's a weather phenomenon, typically in Alberta, but it's also the code name for this AI system that assists Canadian visa officers to decide temporary resident applications such as visitor visas, study permits, and work permits faster. From our understanding, what happens is the artificial intelligence synthesizes the data and then presents it to the officer. The problem is that for whatever reason, the data that the AI is synthesizing for the officer to finally review doesn't always account for everything that was there, or seems to make mistakes. One example we had recently was a refusal for a study permit based on not having sufficient funds, but there was clearly evidence of the amount of money in this case. I think, and I had another case with a person, there was a Canadian host and they had $12 million at savings, and it was refused on the basis of money. So that was, on the face of it, it's outrageous, but I had no doubt this related to the use of the artificial intelligence and its sort of deployment in a haphazard kind of way. So those are the contributing factors for the delays at federal court these days. So with that in mind, let's see here if we see something, right? Okay, so my job is NOC Tier 1 with over 15 years experience, but I'm over 35, but fluent in English. So is it worth attempting to apply for express entry due to age at this point? So there's a bit of crystal ball gazing in this situation, because when express entry came out in, I believe, 2016, we did manage to get people into Canada who are in their 40s, but profile for them was pretty high, and the amount of points in 2016 were like around 440 or 450. So the profile they had were age 40 and 42. Both were fluent in English, both had masters, and they obviously had the relevant experience. So by 2015 standards, it's fine. But we're at the stage right now where there's simply too many candidates in the system, because because it's a Canadian government, every government has to bureaucratize people, which in a sense dehumanizes them a little bit. That's why they call express entry an inventory management system, as if the candidates seeking permanent residency are just boxes of pet supplies or something. So there's too many candidates in the system, leading to the over 500 point mark. The question is, what will happen? So the curtailing of the study permits started in January 2024, but the full effect of that having an impact is only happening now. So there are still people who started a 2-year program, let's say 3 years ago, who have graduated and are doing their PGWP. So from my vantage point, the real drop in points may not happen for another at least 2 years from now, because then we'd see like the smaller cohort of study permit holders who got admission, let's say, for the May 2024 session onwards, and there'd be a lot smaller pool of candidates, because they're only, for example, the changes include only allowing spouses to work of study permit holders if the person's studying in a master's or a bachelor's in certain programs. So there's many disincentives now to get a study permit, and there's also talk of only having a pathway for permanent residency depending on certain jobs. So that means for future candidates, they may not even bother applying for a study permit if they discover the course of study they start in May 2024 onwards may not be the basis for permanent residency. I mean, the strategy for that, I suppose, would be to look at labor market statistics in Canada and fashion your intended study around those, on the presumption that the pathway for permanent residency will still be available based on the labor market needs of the course you selected. So that's sort of again, a bit of editorializing there, right? About how to sort of predict how your application may go if you're over the age of 35. So with that in mind, let's see. Okay, we still have time. So then the other question is, would it be fair to say that the judicial review timeline is 18 months for both the leave application and the JR process? I'd say that is the minimum at this point, because I don't want to, get your hopes up. I mean, it could be smaller in certain situations, like the streamlined study permit pathway at the federal court, where it's just designed to be faster. Further, there's reference to the AI process assisting officers to make decisions on temporary applications. So in terms of how to tackle that, what's the advice that I would give for decisions made by AI, especially for the TRV or study permits? So for this kind of goes back to the whole problem with why there's so many federal court cases, and why they've had to fashion a specific study permit express kind of federal court process for this. The short way to deal with this, if you want to deal with this in the most efficient way possible, is when you encounter a patently unreasonable refusal, then you have to do the reconsideration, saying, in a respectful way, you don't say, "Look, dumbass, here's the document that you missed." You make a respectful request, And then you say, this was the document. And clearly, this person had a bank account with $12 million in it. So I fail to see how the refusal letter says you have insufficient funds to study in Canada. But at the same time, you do the federal court, no matter what the kind of decision is, like study permit or work visa or, visitor visa in some cases. So that would be the two-pronged approach is safer. The reason being is that draws attention to the officer who made the decision, because when you file a federal court leave application, there's a department called litigation management in Ottawa. So they receive the leave application from the federal court, and then they have to contact the visa office and they have to say, you have to dig up the notes for this case. And then the officer digs up the notes and then they send it to litigation management. And then litigation management would say, oh, wait a second. The officer is also saying there was reconsideration. And then litigation management might say, well, there's a leave application, there's reconsideration. The reconsideration looks strong. And then they might advise the lawyer to say, we're going to tell the visa office to cancel the refusal. And then you should just tell the lawyer, we're gonna reopen this case. So just please discontinue the court case, because it saves the immigration department the need to, defend the decision. So there's a bit more money involved, obviously, because you have to pay at least for the first step of the court case, plus have the lawyer do reconsideration if you're not comfortable doing that. But in some cases, when it's what I call a patently unreasonable or wrongful refusal, you have to kind of hit them hard about that, right? You have to really do that, and then it's more efficient, right? So with that in mind, we have 7 minutes. I've given sort of the general warnings to people who self-file, namely declare stuff in the past, either refusals, things of that nature. So in other situations, I'm trying to think of the other sort of general things that people ask me. For example, in consultations, they say, is there anything else I need to know? So I'm thinking of the responses I give to people in those situations. So aside from litigation types of situations where you're called or subpoenaed as a witness, where then the strategy is know what your case was about and listen to the question and answer the question. That's sort of a case when you're called as a witness, let's say in a spousal case. And then you have to know, obviously, the nature of your relationship. And then your case is refused. You end up at the Immigration Appeal Division of the Immigration and Refugee Board. And it's like a trial. It's a court. You're examined by your lawyer. You're cross-examined by the opposing lawyer. So in those kinds of situations, it's listen to the question, answer the question, know basics about your marital relationship. That in the days where it was common to have interviews for permanent residency for skilled workers, we would have to give that kind of advice. But now everything has become so, I don't want to say streamlined because that's too positive, but because everything is paper-based, you don't even know the name of the officer. Now they have a code. You can't pick up the phone anymore to contact the department about something sort of simple, which can be resolved. In addition, they don't give us the names of the managers of the visa offices anymore, so we can't ask the manager of the visa office saying, here's the refusal your colleague made, can you reopen that? So because of all that, that goes back to either having to refile with a refusal and explaining the refusal, or seeking judicial review at the federal court for this. So again, that's why federal court is backlogged. They're asking us lawyers at the Canadian Bar Association, what are your ideas for streamlining this entire process? So I don't know if they're going to listen to us, but we have some very strong opinions about how there should be cost consequences on the immigration department in more specific circumstances rather than costs on the basis of special reasons. So costs are like, when you win a court case, you get some money back because you should have not had to have gone to court. In the immigration sphere, that's very rare. That's why you have to have special reasons for costs, unlike regular civil litigation where costs follow the event, which means whoever wins gets some money back for the hassle of going to court. So I think that may be part of the idea about how we could incentivize the immigration department to actually compose or create a more incentivize them to create a more robust reconsideration system rather than something sort of informal and risky. So those are the ideas that we kind of are hoping. I mean, there's other ones too that we're sort of thinking about, but we're at the point where the federal court presumes we have some expertise as lawyers who go to federal court, so they're canvassing us immigration lawyers, and because of the artificial intelligence, they're canvassing the intellectual property lawyers, which that type of work is done at the federal courts, and things of that nature for those kinds of potential innovations to deal with this deluge, really in everything. It's basically this whole phenomenon of now that everybody has access to the immigration forms. You don't need a lawyer in theory necessarily. So everybody is filing tons of applications and they're maybe refiling them. And so that's hamstringing the immigration department with so many applications because it's so easy. And now you can just do a web form to make a query, but now there's like 1 million emails or web form messages they have to deal with. If you're lucky, you'll get a response in 30 days. Sometimes you get no response. So it's almost as if there's just sort of an intensive onslaught of visa applications, and it's becoming really too much for the immigration department to handle, leading to wrongful refusals, and then it's having a cascading negative effect on the federal court. So that's sort of the lay of the land these days in the past 20 months or so, where this has been proliferating. So with that in mind, I've got 2 minutes left. I don't see any questions here, so I may be able to give you 2 minutes back of your time, but I do want to have this call to action at the end, which is if you do have a Canadian immigration visa query or a visa refusal, you can contact us at Chaudhary Law Office, and I'll just have the, just for completeness sake, I'll just send the sort of intake email. And then the domain obviously is chaudharylaw.com. And although we have, like most lawyers have, paid consultations, I try to have these webinars because people say, well, what do you do